as to bond.
Well, I don't know what consent as bond argument is going to be. I'm not happy about that, but Mr. Mikowski Smith comes before your honor. He's a very young man with no history of assaultive offenses. He lives at home locally. He works a 40-hour-a-week job at Slim's Chicken. I know after I'm done speaking, Ms. Senda is going to get up and read the police report, and it might
You
not.
don't know that.
Go
with your.
Okay. Okay. Nevertheless, Mr. Mikowski Smith, if the court is gracious enough to consider releasing him, he will go home. He will stay home, with the exception of going to court, going to work, and that's it, Your Honor.
Counsel.
Your Honor, at this time, we would be asking that the defendant's phone privileges be revoked. He's been contacting his mom and telling her to contact the victim, saying things like, I got court at 10 in the morning, they already told me, and if I get convicted, it's a felony myself, but I definitely need to talk to them next day on that. He also says, right now today, you gotta let her know, if she, oh my God, when we get off the phone, I need you to call over there immediately. And then he says, you make sure what's her name knows not to come at all. Basically, nobody on me, I'm good. So try to let that be known. Just try to let that be known so that it's contact the victim from third parties.
And I doubt any of that was in the police report, so she didn't read it. Response.
I have no response here.
Motion for bond reduction is denied. Phone privileges are revoked. You can ask for a hearing if you'd like. Thank you.
Your Honor, I would like to, and I see that he's being held right now, but I would like to address bond in this matter. So my client was found not competent.
Hold on. Is he being held on the other matter? Okay, silence. That means I asked a good question.
You asked a really good question, Your Honor.
Yes, he is held on the other matter until February 20th on a $1,000 bond. The bond in this case is $100. The felonious assault. It is PCC.
Your Honor, I'm still going to address bond, and if the court would allow me to, please.
Yeah, go for it.
And I understand the court's position here, but my client.
What do you mean you understand my position? I'm saying he's held on another case, so I don't know what you want me to do.
Your Honor, I want to get this. Will the court please just indulge me for a moment? I want to address bond.
I don't have a choice. Go ahead.
The reason why he was being held in the first place was on the case out of the 15th, where he had been found not competent, and they did a involuntary commitment order, but they found him not competent, and the case was dismissed. And since then, my client has just been held and held and held and held. And while he's been held because he's not competent, because he has mental health issues, he's collecting these cases. Your Honor, I don't understand how he was still held after the case from the 15th District Court was dismissed.
I don't know. But he's held on another matter at this point. Right? What is that other matter?
Hold on, that's a solid case. Which case file are you talking about? Because the FA case that he's in custody is a 15th case that hasn't been dismissed. Do you have a case file for the dismissed 15th case number?
Your Honor, I actually put it on my notice to request the adjournment.
Is it
24-1311 SM? That would not be a felony case.
That's the case he's been held. That's the only one.
That's not the case he's being held on.
Okay.
Held on is 24 F5 5228.
Thank you, Your Honor. And I'll look into that as well. But again,
and that's an assault that he committed in the jail before his 15th case was dismissed. So he was in custody on the 15th case that you're now saying has been dismissed.
Has been dismissed, yes.
He assaulted somebody in the jail before that 15th case was dismissed, and he is in custody for that September assault.
Which may explain why he wasn't released.
Thank you, Your Honor.
Motion for bond reduction denied. Go ahead.
Thank you, Judge. My understanding is that the last court date, the court told Mr. Washington that he was to come up with a plan as to what would happen should he be released. I believe Ms. Ikariakan-Ruli had to file at that time, and she indicated that he was to go into the CCOP program. She reached out to Ms. Maya Dozier, and our understanding is he cannot be evaluated for that program while in custody. He has prepared a plan, is my understanding, as a letter for the court, if the court wants to review it, is what I am told. And so his request is that the court would release him on a tether if necessary, so that he can go into the CCOP program, be evaluated by Ms. Dozier. And he does have family support here who would help him in any way, with his mother and his father are both in the courtroom. And so that's what his request at this time.
Oh, they're back. Okay. Okay. I just wanted to.
Yes, Judge. And so that's my understanding as of what occurred at the last court date and what his request is.
They're gonna get into CCOP program.
Yes, Judge. Since his bond's been revoked, he's been in here 3 weeks, and I think he has faced some harsh realities that what happened.
Harsh realities of what?
What happens when you don't listen to Judge Simpson, when you don't follow your bond conditions.
Oh, that harsh reality?
Yes.
How's it been going?
That's so good.
So, how do you think you ended up here?
By not being truthful to myself, honestly, like I said the last time, and not being truthful to you, most of all.
And there's another person you weren't truthful with.
My mother.
Yeah. Out of all of that, that was the one that upset me. How old are you?
24. I'll be 25 on a Monday.
Oh, so we could keep you for your birthday?
In theory, you could, yes, Judge.
That's pretty cool. Do they do cake down there? No, they don't? No cake? Oh, bummer. You know something, young man, and it's kind of funny because when I sit up here, I kind of look out and I see people, and sometimes I see moms, and moms are here. You may not have done the right thing, but mama's going to be here to protect her baby, or as best she can. And when she got up and walked all the way across the courtroom to get away from that other, whatever her name was, she knew you were in trouble. Mom, you want him? You do? You're so lucky she didn't say no. Because if she had said no, you'd just be my guest. Is there anything from the people regarding this?
It's a copy of the letters going to go to the court. I'd like to see it before it goes.
I haven't seen. I
I
haven't
didn't know if it was
seen.
gonna go or not. That was.
Do you need to see it?
I don't need to see it.
Well, as long as the court continues the testing, the people have no objection to this change in bond. If there are any positive tests, we will be asking them to defend it on your vote.
Again.
If there are additional positive tests, I should say, yes, there's 2 previous positive tests of great concern.
You know, some young man, you need to stay away from that stuff because either you're going to end up in jail or you're going to end up dead. That's just going to be the reality.
Sure.
So he's to enroll in the CCOP program. I'm going to put him on a GPS location tracking tether, and we'll reinstate his previous testing. You're on thin ice. You need to follow all of this to a letter.
Sure.
So he's to enroll in the CCOP program. I'm going to put him on a GPS location tracking tether, and we'll reinstate his previous testing. You're on thin ice. You need to follow all of this to a letter.
Sure.
Those previous bond will be reinstated with a GPS tether. We'll see him on the 6th.
Thank you very much, Judge.
Thank you.
Let you-
Young man, Don't thank me, thank your mother for you having your freedom today, as well as your life when your birthday comes around. Mom, thanks for coming down.
Are you ready?
That's funny. Dad was there. Dad didn't do nothing. He just, I'm just saying, you didn't do nothing. Mama was it. All right, take care.
Judge, I'm gonna be in the middle of, I think my CSC trial is probably gonna go most of the,
February 13th.
thank you, Judge. Appreciate it.
No, you don't.
I-
2025, 9
Really do,
a.m.
Judge.
Bond continues.
Oh, Judge, just one quick note. She's a top chef. She's been on tether.
She's what?
She's a top chef. She is on a GPS tether. She's only been on it 2 weeks. There's been no violations. It's hindering her work. She lives nowhere near the alleged victim in this matter, and she's asking if the court would please consider. She seems like a very honest woman to me, that she will have no.
is it?
Pardon me?
What way is it hindering work?
Because I'm actually kind of the face of my job. All my other employees, everybody works kind of the back. I'm the one that's serving food. So my boss yesterday told me just, hey, it's not really a good look for the company with me walking around with the tether, kind of serving clients of different businesses and different clients we have, dropping off orders that I pretty much I deal with. I deal with all the ordering and different things.
Response.
Your Honor, we would object to any modification of the bond. Given the facts of this case, the defendant broke into the victim's residence while she was out of town, threw bleach on her clothes and damaged them. Also, stole $350. We feel a tether is extremely appropriate.
Judge, again, not to argue the case here, that's just a bunch of baloney. This lady was invited over there. It was a past relationship, and she went over there. The lady told her where to go into the house. Nothing was taken. Nothing was destroyed. She lives nowhere near this lady. She's a hardworking lady. I don't want to lose her job. Would you please?
Well, I don't want her to lose her job either, but I think you're saying she was invited over. That's not the facts that we have in this case.
Judge,
Invitation.
when we hold the exam, there will be texts showing that she was invited over there. She went over there. There was nobody home. She left. All of a sudden now, later, that says this is taken. This.
Well, if you have those messages, I'll consider them, but I don't have them in front of me.
Yes, sir.
I don't have them in front of me at this point. So certainly you can raise that before me, Mr. Killawall, get it to the prosecutor. We'll take a look at it.
Yes, sir.
But at this point, motion for bond reduction from that.
Thanks, Judge.
Somebody could do this.
Judge, I was just appointed on the case. I talked to her last night. She said,
I heard that.
and she said she sent me the text messages. I will forward to the prosecutor and to your honor. And hopefully you'll change your mind,
Your Honor, may I speak or?
just real quick.
Am I able to?
I guess he gave my answer. Go ahead.
Okay, sorry. So just really quick, I was in touch with another attorney, so he was, of course, just appointed to me. My other attorney, I have sent them all the text message proof. She has tried to contact me through everybody else even around.
Ooh,
My ex-girlfriend, we used to live together, and pretty much we used to live together. We had a breakup where I stopped having contact with her. We were actually raising a child together. So she pretty much lured me by blowing up my phone, literally, every single day up until I went over there saying to come over.
I understand. I may understand all of that.
Yes,
What I'm indicating is that I don't have anything to the contrary of what I have. If you send it off to another attorney, you need to get it from them and get it to Mr. Killawall
yes,
so
sir.
he can do what he just said he was gonna do.
Yes, sir. I was asking because I live nowhere near this area.
I
So I was
heard that
asking-
also.
Yes, am I able to show the messages to him today to be able to show to you today? You know,
I think that if you get them to your attorney will then make the decision as to getting them to the prosecutor and then how to get them to the court.
yes, sir.
we'll do that today.
Anything
Okay,
else?
yes, sir. Yes, sir.
Thanks, Judge. We do appreciate your consideration in this matter.
Yes.
Thank you.
Thank you.
Thank you.
Yes, same. Court call.
Mr. Driscoll would very much like to get this matter resolved as quickly as possible. I spoke to Ms. Zinda about it. At this time, there isn't an offer yet. She has to speak to the victim in this case.
How did your conversation with Ms. Indigo?
Went well.
Did she just
pleasant.
repeat the police report to you?
No,
No, I just thought I'd
she
ask.
didn't have to, Judge.
I just thought I'd ask, because that's what I'm hearing.
Oh, no, she didn't.
Oh, okay. All right. That's what I thought. I
She was
didn't
very
think she
pleasant.
did that. I just thought I'd ask.
So my client wants to get it resolved as quickly as possible. He's
All
asking
right.
for a 1 week adjournment if the court granted, but I told him the court would.
Are you gonna be able to get it done in 1 week?
She'll talk to the victim, I'm sure, within a week and let me know if
That'll
they're.
be fine, Your
Oh,
Honor.
that was cordial.
Thank you, Ms.
And
Zimmer.
again, it had nothing to do with the police report. The 30th.
Thank you, Judge. Next week. And I do not have a bond argument. Thank you.
What'd you say?
I do not have a bond argument.
You don't? Okay,
Oh,
good.
now he does.
He does now?
Yes, Judge. My client is asking Your Honor to consider a personal bond in this matter. He says he does not have a violent record and he would like to be able to be released. But we talked about this in holding. I told him if you gave him a 1 week adjournment, you're unlikely to change the bond. But he is asking that you change it anyway.
Okay, now here we go. Ms. Senda.
Given the defendant's history, he has a DV from 05 and multiple, or a dismissed DV, child abuse fourth, and 2 AMVs. In this case, they had been dating 2 years and the victim was 3 months pregnant with his child. He was upset that she wasn't getting an abortion, stated, "You're not gonna get rid of that baby," and pulled out a folding knife on her. She went to the bathroom, locked the door, and called 911. She then attempted to leave the store that she was working at, grabbed her by the throat, he then headbutted her. He then began to demand that she give him her phone as she was calling 911 and was pulling her across the floor of the store by her hair before fleeing. Immediately after fleeing, he then called 911 himself to say she was making a false report and that he was in Detroit, when in reality, it was shown that he was in Ipsy. Her dispatch is at House of Liquor. Do you have facts in this case, Your Honor?
Nothing conditional, Your Honor.
I'm surprised his bond is actually so low, but I'll leave it where it is at this point in time. Motion for bond reduction is denied.
Thank you, Judge.
Bond will-
For the hearing.
Oh, sorry, Judge.
No, you're not. You just kept going.
That's my fault.
No, it was not your fault. Don't cover for him.
I did not hear you, Judge. My apologies. I was having a spirited conversation with Ms. Lundy.
Is there any other time?
That's what I'm talking about.
Thank you, Judge. This is a case with a substantial amount of restitution. My client is in the process of selling properties. He is asking for one last adjournment. He said if it's not sold by then we can proceed. But he's hoping to be able to pay it all off, Your Honor. He said about 4 weeks.
I know he was trying to sell it the last time.
Yes,
and-
they just came the holidays and and that, so it kind of postponed things and bureaucracy with paperwork and that. So I need one last time, please.
Response from the people. Because I remember your last time, because you kept saying, we're never gonna do this again. It's not gonna happen. I remember the whole thing. It's like ingrained in my brain, but go ahead. What's the story today?
Great day.
Yes, it is.
Beautiful day. So for the record though, we've been adjourning this case for several months. I want to say since August.
Okay.
And the defendant keeps saying he wants to sell property, sell items to pay restitution. I have no record of any request to actually start putting restitution to the court of any kind. And we've been very clear with this case that there will not be a misdemeanor offer. Oftentimes, I know that there can be arrangements made for someone to continue to pay restitution in the hopes of receiving a misdemeanor. We're talking over $130,000, I believe, in this case. We're not in misdemeanor territory. There will not be a misdemeanor resolution. So I understand the defendant wishes to have another adjournment, but unfortunately, there's been no monies paid to the court for restitution. There will not be a misdemeanor offer. So I'm leaving it in the discretion of the court, of course, but I'm not sure we're accomplishing anything here other than just delaying the proceedings.
Obviously, Your Honor, my client has lost it.
Wow. Yes, it's very succinctly put.
It was. She's an excellent attorney, Judge.
Oh, she is.
Yes. But
Because she told you this the last time, but you didn't listen. So go ahead.
thank you. Obviously, there will not be payments in this kind of case. It'll be a lump sum if he's able to make the sale of the property. He's not working. He lost his job as a
Is this
result.
real property he's trying to?
Yes,
sell?
Judge. So this would be a lump sum type of deal. If for a middle ground, if the court would consider.
A middle ground?
Yes, Judge. To move the case.
A
forward.
compromise.
Yes, Judge.
Ah.
We can set this for exam in 4 weeks. And at that time, it will move one way or the other, if the court is inclined.
Has the paperwork been done regarding the sale of the property? I'm looking at a victim that obviously would need to be restored. And
Yes.
maybe this is the way that it can happen, although irrespective of any plea, I'm not saying that.
Has the paperwork for,
The sale of the real estate, and where are you on that?
Overseas,
Pardon?
overseas.
this overseas
That's
property?
my other understanding is
Yes.
this is property that's located outside of the United
Yes.
States.
Oh,
Yes,
Which
and,
is-
and my family is working on that process, and it just, it took longer than I was expecting.
He did tell me that
Yes.
his family has a similar property that they
Yes.
sold last month
Yes,
that would have netted enough to pay the restitution. So
Yes.
he's optimistic
yes,
that this will be sold in 4 weeks and he'll have enough to pay a lump sum and pay the restitution off in full so that the victim in this case is made whole.
give him one last shot at it.
Thank you, Judge.
February 20th, 2025. And bond continues.
Your Honor.
And you know,
Yes,
Ms. Lundy's position isn't going to change.
I know, Judge.
So
But-
if you're trying to wear her down, it's not going to happen. I'm just saying,
So, money changes things. And off a big lump sum like
not
this.
going to happen. Telling you right now. It's been before me for years. Not going to happen.
Well, you know it better than me, Judge.
You give it your best shot.
I will. Judge. Thank you.
As to bond.
As to bond, he did turn himself in on January 13th on the warrant. He was not picked up on this case. Looking to resolve this matter and a matter that's upset or that's set up in circuit court regarding child support.
Say that part again.
That he turned himself in to take care of this warrant that had been issued and another warrant that was issued regarding child support, which he's trying to resolve up in circuit court. He's looking to resolve both these matters.
But is he being held on the child support?
He's not being held on the child support. He also resolved a failure to pay out of the 14B district court that has a court date coming up next month. That also is
What date?
I will understand 2/15.
And is he being held on that?
Not being held on that case either. If he were to be let out, he would abide by any community corrections order. Actually, we'd be requesting it based on the charge.
At the time of the arraignment, did you have a hold for the child support?
No, sir.
Motion for bond reduction is granted. Granted defendant $25,000 personal recognizance bond. Defendant is to report to community corrections for 2 times per week testing.
Thank you.
thank you, Your Honor.
Regarding the adjournment, I don't know how long it would take to obtain the video, 2 or 3 weeks I'd be asking for.
Didn't I already give it a day?
February 6th.
Oh,
Yeah.
I didn't write it down.
It's
yet.
written right here.
Thank you.
Your client knew. Didn't you?
He's smart, Your Honor.
No, you knew, didn't you?
Yes, sir.
He wasn't listening. We'll work on him on it.
Yes, sir.
All right.
Too worried about the bond argument.
Thank you.
Thank you.
Thank you, sir.
Well, that was one good deed I've done today. It's over now. No more. Tell him, well, it's not that big a deal. I'll reduce the bond if you give me something to work with.
That is for law students to watch, that argument.
Mr. Dukas gave a good argument. Nothing like yours.
That's true.
All right. Court has called a contender plea in another case that's set for prelim.
Yes, yeah. So case 24F55262, just because of the timing with the mental health treatment court evaluation, that one was set for preliminary examination before the evaluation was complete. And that is currently set for exam.
So over there is Ann. Right?
Yes,
You know Ann?
yes.
Okay. So if you had this, that may work out where we could like get rid of 2 cases and he could plead. I may or may not do it, but usually just go over and ask Ann. Because you asked me on the record, I'll probably say no, because I don't do the filing, so I don't know where it is.
Understood, yes. So I will,
So would you like to do that today?
I would like to.
So here's what I'll do. I'll pass it. Go talk to Ann.
Thank you very much, Your Honor.
You're welcome. Ann, don't talk to me. Court calls